So let's talk just a little bit about the U.S. Supreme Court decision in Students for Fair Admissions v. Harvard. But students are, there's, I think, one more word in that, the official name. And so what did the court say there? And of course, there's a ton of literature out there. There are the decisions as well. And I think they're worth reading if you're interested in this area. As I said earlier, the point here is not to do a lengthy talk about the footnotes, the different opinions, et cetera. Sort of give the background and then tie it into kind of our topic sentence. So, but the holding is that affirmative action programs at universities receiving federal funding, which is most universities, failed to satisfy the restrictions of the 14th Amendment's Equal Protection Clause. And so aspects of that the court cited, the goals of the programs were not sufficiently measurable. The programs failed to articulate the connection between the means and the ends. They explicitly used race as a negative or positive, and they had no logical endpoint. So just, I was talking at lunch today with some people, about what I was doing this afternoon, and we were just talking about this decision a little bit. And what I said is, I think ultimately, in summary, the court found, it was a little squishy. That was not their word. That's my very non-legal summary word. And I think no matter what you think about the decision as a whole or the outcome as a whole, and we are, I'm not an expert on college admissions, but I know there's been data out there that you are seeing in incoming classes at some of these institutions already lower representation of minorities. So no matter what you think about all that, I think it's not entirely unfair that at least some of the court's criticisms are not entirely unfair of the programs as far as sort of the rigor of it. You can disagree with that, but I'm not, I don't think that was a super extreme statement. At least you can understand, I think, where that opinion is coming from. So legally, this really doesn't have a lot to do with DEI in the employment setting. So say corporate programs to enhance diversity in their employee base. Employment discrimination is largely governed by Title VII. Certainly there are other aspects, Americans with Disabilities Act, age discrimination, but race, gender, religion, those are governed by Title VII of the Civil Rights Act of 1964. That was not at issue in the Students for Fair Admissions case. That's not what was before the court in the case. Most private employers, so if you're like me and you're a management side employment lawyer, most of our clients, our private clients, are not educational institutions, are not receiving federal funding. And I think this is really important. It's always been true. I mean, always, and since I've been practicing, that quotas express consideration of protected classes that are identified in Title VII have been, that's been illegal under Title VII. So, for example, a lot of law firms, just to sort of reflect on our industry, would have programs to attempt to enhance diversity of their associates and beyond, but I'm focusing sort of on incoming hiring. And you'll see some law firms that would be phrased, in the job listing on their website or what have you, that would be phrased as you need to be a member of some historically disadvantaged class, or might identify those classes. Other law firms, and these are big, sophisticated, high-level firms included, others would be more something along the lines of a candidate, should enhance our firm's diversity, equity, inclusion efforts. And as part of the application, the individual would explain how they do that, which you could do in a lot of ways that and may or may not be a member of the class. So